Court on Monday, September 18, in which they are requesting a Franks hearing for their client. A Franks hearing is derived from a 1978 court case, Franks v. Delaware, dealing with defendants' rights to challenge evidence collected on the basis of a warrant granted on the basis of a false statement. The court held that where a warrant affidavit contains a statement, necessary to the finding of probable cause, that is demonstrated to be both false and included by an affiant knowingly and intentionally, or with reckless disregard for the truth, the warrant is not valid. According to the defense, the Franks hearing is intended to detail the long list of specific information in the search warrant affidavit. Then lead detective in the case, Tony Liggett, chose to hide from Carroll Circuit Court Judge Benjamin Deiner, as well as information contained in the search warrant affidavit that are flat-out falsehoods that Liggett swore and affirmed were true. A memorandum which explains in detail how the defense asserts that the search warrant was illegal is attached to the filing. The defense is alleging the search warrant was defective because it was vague and contained untrue statements from Liggett. The defense will be requesting the court to suppress all fruits, evidence collected, of the illegal search. The motion states, the motion asserts that, on October 13, 2022, following a roughly hour-and-a-half interview with the accused, Rick Allen, Detective Tony Liggett signed an affidavit for search warrant, which was a 5-page document detailing information concerning said interview with Rick Allen, as well as information flowing from a 5.5-year investigation into the murders of Abigail Williams and Liberty German. According to the filing, the affidavit for search warrant was also approved by a second signatory, prosecutor Nicholas C. McLeland, before being sent to Judge Deiner for further review. The purpose of the affidavit for search warrant was to provide a sworn statement containing information from the lengthy investigation which would convince Judge Deiner that a reasonable belief existed evidence of said murder would be found in Rick Allen's home and vehicles. The affidavit for search warrant was apparently reviewed by Judge Deiner, who then signed a search warrant for Allen's home and vehicles, at 6:37 p.m. on October 13, 2023, that on its face and within the four corners of the document, the affidavit for search warrant was defective in that it did not provide the type of information that would cause any reasonable person to believe that it was more likely than not evidence of the murders of Abigail Williams and Liberty German would be found in Rick Allen's home or vehicles, especially more than 5 years after they were murdered, because, on its face and within the four corners of the affidavit for search warrant, no reasonable person would believe that it was more likely than not that evidence of the murders of Abigail Williams and Liberty German would be found in Rick Allen's home. The affidavit for the search warrant was filed September 18, 2022 at 2:06 a.m. in the Carroll Circuit Court. The defense contends Judge Deiner erred in signing the search warrant. Therefore, any search of Allen's home and vehicles was illegal. Therefore, all items seized pursuant to said illegal search should be suppressed. The motion continues with, however, making matters far worse, Detective Tony Liggett chose to hide crucial information from the search warrant affidavit and provided false statements in said search warrant affidavit. According to the filing, the defense is required to make a substantial preliminary showing omitted, or false statements, were made knowingly or intentionally or with reckless disregard. If the trial court concludes the omitted facts or false statements were necessary for the finding of probable cause, then the trial court should set a hearing on defendant's request. Furthermore, Indiana courts have held that when material information is omitted from a probable cause affidavit, such omissions will invalidate a warrant if 1. The police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading, and 2. The affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. Had Liggett actually included said information within the affidavit for search warrant, then Judge Deiner most certainly would not have signed said warrant, as the hidden and false information was the type of information that any reasonable person would have known was the kind of thing the judge would wish to know. The document stated. The defense also filed a memorandum in support of the motion for Frank's hearing. Once the court has reviewed the motion for Frank's hearing, Richard Allen would ask this court to set this matter for a hearing. The motion stated. Memorandum. In part, the defense concludes that 1. Members of a pagan Norse religion, called Odinism, hijacked by white nationalists, ritualistically sacrificed Abigail Williams and Liberty German. 2. Very early on, those in charge of the Delphi murder investigation, Unified Command, claim that they consulted with a Purdue professor concerning what resembled possible Odinism signatures left behind at the crime scene. After the Purdue professor proclaimed according to State Trooper Jerry Holman, that it was not Odinism or any type of cult worshipping or any type of group that would have conducted the crime. The Odinism angle was essentially abandoned. However, as of September 7, 2023, the leaders of the Delphi investigation team, 1. claim that they can't identify who this purported professor was, 2. have provided no reports from this purported professor, and 3. have further indicated they may never be able to figure out who this professor is. The memorandum stated that, based in large part upon this mystery Purdue professor's opinion, the Delphi investigative leadership claimed that it essentially abandoned considering Odinite involvement in the murders. During the passing years, law enforcement officers Kevin Murphy, Greg Ferenczi and Todd Click continued to pursue the truth. According to the document, because of their curiosity and investigative efforts, the evidence establishing the names of the likely murdering members of this Odinite cult became known to the Delphi investigative leadership no later than February 2018. Due to either incompetence or a concerted intentionality, those in charge of the investigation refused to arrest or even properly investigate these obvious suspects. Further, it is written that on May 1, 2023, the state of Indiana, by way of prosecutor Nick McLeland, SP, received a letter from former Rushville Assistant Police Chief Todd Click, now retired. Click, Murphy and Ferenczi were three of the law enforcement officers who worked on the Delphi murder case, particularly focused on the Odinite angle as it intersected with suspects in Rushville, Indiana. After reading Richard Allen's probable cause affidavit, Click became concerned that the information contained in Richard Allen's affidavit pointing the finger at Richard Allen was far less compelling than the totality of the information that Detective Ferenczi, Detective Murphy and Officer Click had accumulated during the Rushville portion of the investigation. The information Murphy, Ferenczi and Click had gathered during their investigation connected men who practiced Odinism in or near Delphi with another group of men who lived in Rushville and then connected both groups of men to the murders. Click was concerned that for some reason the leadership of the investigative team had failed to share with Prosecutor McLeland, SP, the evidence gathered by Click, Ferenczi and Murphy. Click's concerns led him to seek out a lawyer to assist him in the drafting of a letter. This letter was then sent to McLeland. However, the defense states that this letter was not provided to the defense until after it was obvious from the last round of depositions that the defense, who had doggedly pursued witnesses as far away as Georgia, would certainly be talking with Todd Click. McLeland, SP, had this letter in his possession for over 4 months before turning it over to the defense. There can be no mistaking that this letter is exculpatory, tending or serving to clear from alleged fault or guilt in nature and could have been used by the defense as it prepared for upcoming depositions. However, it is apparent that McLeland, SP, only offered up the letter after it was obvious that the defense team would soon be learning of the letter's existence. In other words, the defense team would obviously be meeting with, or deposing Click in the next few weeks. Click most certainly would then reveal to the defense at that time, that in April 2023, he, Click, had sent a letter containing exculpatory information to McLeland, SP. The defense alleges, McLeland, SP, had two distinct choices at this point. 1. Sit on the exculpatory evidence hoping that the defense team would refocus its efforts on another angle of the investigation, or 2. Disclose the exculpatory evidence claiming that the contents of the letter were overlooked in the volume of discovery. He chose the latter. Unfortunately for the state, neither approach explains away the fact that Click specifically directed the letter to McLeland himself, and further, Click was so determined to ensure his information was consumed by McLeland, that he directed the information directly to McLeland, via certified mail. The letter is stamped received May 1, 2023. Carroll County Prosecutor Click's report landed at Ground Zero, a prosecutor's office with no more than 2 full-time prosecutors and a handful of full-time staff members. At best, it is not plausible that this exculpatory evidence could have been completely overlooked. Not only did the prosecution withhold that letter from the defense, according to the document, but law enforcement also withheld several other exculpatory pieces of evidence, including an 85-page compilation of reports by Click prepared in 2019 and several videos containing statements that support the defense theory of Richard Allen's innocence. This 85-page report detailed the investigative work performed by Click, Ferenczi, Murphy, and others, including the FBI. Not only did Carroll County Detective Tony Liggett fail to include all this Odinite information in his October 13, 2022 affidavit for search warrant. And not only did McLeland, SP, and the Unified Command withhold exculpatory evidence, Liggett also concealed damaging witness statements that devastate Liggett's timeline, a timeline Liggett allegedly needed to be true in order to place Richard Allen at the trail when Abby and Libby were abducted. Additionally, Liggett lied in his affidavit about the statements of another key witness, further devastating Liggett's timeline. Richard Allen has zero connections to any pagan cult or pagan cultists, and furthermore no forensic evidence, such as DNA or electronic evidence, links Richard Allen to the girls or to the crime scene, i.e., he is a completely innocent man. Most of the evidence backing these assertions was found scattered over no less than 10 hard drives and several flash drives provided by the prosecution, meaning that the defense is not making wild accusations, but rather primarily relaying facts and information that is backed up by the prosecutor's own discovery, even discovery that the prosecution provided to the defense as late as September 8, 2023. Evidence supports that at the crime scene, these murdering Audenites left behind obvious signatures, symbols in the form of runes. These runes were formed with sticks, fashioned with tree branches. Sticks and tree branches were deliberately, carefully and proficiently placed in a certain arrangement mimicking certain runes. At least one of the branches appeared to have its end cut off cleanly by some type of tool like an electric saw, providing proof of a preconceived plan. With a simple Google search, these runes would be identifiable as one of the many calling cards of this pagan religious cult. Yet, law enforcement in charge of the Delphi investigation seemingly, and quickly, abandoned the obvious correlation between the crime scene and Audenism. Despite a significant amount of evidence linking Audenism to the crime scene, and even in spite of powerful evidence linking specific Audenites in and around Indiana to the murders. Also, the court will learn in his affidavit for search warrant that Liggett failed to inform Judge Deiner that nothing, absolutely nothing, links Richard Allen to Audenism or any religious cult. No forensics, such as DNA, no electronic data extracted from his computers or phones or from his social media links Richard Allen to the crime scene. Richard Allen had nothing to do with this crime, but rather is an innocent man, a patsy for the police, and arrested 26 days before the sheriff's election. According to the document, the defense believes the court will be shocked at the number of clues or Easter eggs, both before and after the murders, that one Audenite openly posted on his Facebook page that pointed the finger to his involvement in the murders. The evidence will show that Tony Liggett knew of the major problems that these witnesses' testimony created, and Liggett chose to solve his problem by concealing this information and even falsifying other information in order to bolster the state's bogus timeline. The evidence will show that Liggett concealed facts concerning descriptions that key witness Betsy Blair made directly to Liggett, face-to-face, in 2019 concerning the person that she, Betsy Blair, observed on the bridge and a vehicle that Blair observed at the CPS building parking lot at around 2:15 p.m. on February 17, 2017. For Liggett's timeline to work and to place Richard Allen on the Monon High Bridge at 2:13 p.m., the time of the famous Down the Hill video, Liggett desperately needed Betsy Blair to describe a man on the bridge that looked like Richard Allen, and he furthermore desperately needed Blair to describe a car that she observed parked at the CPS parking lot, at approximately 2:15 p.m., as looking like Richard Allen's black Ford Focus. Suffice it to say, the evidence will show Liggett concealed from Judge Deiner that Betsy Blair described a man on the bridge that looked nothing like Richard Allen and described a car at the CPS lot that looked nothing like Richard Allen's car, both in color and design. The evidence will show that Blair provided these timeline-defeating descriptions directly to Liggett, face-to-face, 2 times in 2019. Yet, Liggett failed to inform Judge Deiner of these descriptions, as well as inform Deiner of the fatal flaws that these missing descriptions created for the timeline. The document states the evidence will also show Liggett just flat out lied about what Liggett claimed Sarah Carbaugh told him in 2017 concerning a man walking down the road near the murder scene. For Liggett's timeline to work, Liggett needed Sarah Carbaugh to describe a man walking down the road wearing a blue jacket, who had blood covering his clothing. However, in 2017 Sarah did not say these things. This did not prevent Liggett from affirming under oath that Sarah Carbaugh did say those things. In fact, what Sarah Carbaugh actually told Liggett in 2017 was that she, Carbaugh, observed a man walking down the road wearing a tan coat whose clothes were muddy. Nowhere did Carbaugh claim in 2017 that the man she observed was wearing a blue coat. Nowhere did Carbaugh claim in 2017 that the man she observed was wearing bloody clothes. This truth about what Sarah Carbaugh actually told Liggett in 2017 blows up Liggett's timeline, which is the likely reason Liggett failed to include this information in his affidavit. The defense stated it believes the evidence strongly supports the contention that Liggett intentionally concealed evidence from Judge Deiner and lied about other evidence to Judge Deiner in his affidavit for search warrant. However, even if Liggett did not intentionally conceal evidence from the judge or did not intentionally place false information into the search warrant affidavit, at a minimum Liggett behaved recklessly when he prepared the affidavit, omitting those facts from Judge Deiner and providing false information in the affidavit. As stated in the motion accompanying this brief, the